the Information Technology Act. Again, this is legislation that was passed in the year 2000 for doing various different things with respect to the digital electronic space. So it covers things like the regulation of e-commerce, what is the value of a digital signature, how is electronic evidence supposed to be collected, and also is a legislation that recognizes certain specific crimes specific to the internet, and the protection of certain rights of persons on the internet. So the chapters that are relevant to us, again, I'm not going to go through the whole of the legislation, but the chapters that are relevant to us are chapters 9 and 11, both of which are chapters that provide for certain offenses. And there is some good and there is some bad in this legislation. There are certain important things that I feel the Act does, which is in terms of, say, considering how hacking, phishing, identity theft, etc., are to be considered, which will and has affected a lot of people. And the IPC in and of itself would not have been able to identify these crimes or think of them as separate crimes. So there is the identification of a whole range of new crimes that the Information Technology Act has allowed for. Also things like, say, child pornography or pornography against a person's affecting the right to privacy when it's not something that a person has agreed to. So there is a range of these offenses, and the IT Act is important for that. But there is also the IT Act is constantly in debate because of the restrictions on free speech also that one may look to. So in the Shreya Singhal case, the Supreme Court struck down one section of the Information Technology Act and read down a few other provisions in order to then say that there cannot be this broad crime that is defined where any and all speech on the internet became susceptible to being considered to be a crime. So anything that was said in criticism of the government, in criticism of other people, all of that started coming under Section 69A. And there was a lot of debate on whether this was in fact restricting free speech. And the Supreme Court then held that this particular provision, I'm sorry, it's not 69A, 66A, was scrapped for saying that it's too broad a definition of what could be a crime of speech, and unless and until there are specific restrictions that are imputed to the law, this cannot exist as it is. But it also upheld certain other things, and what it did uphold is the right of the government to block content. And this is important because this is another controversial area on the internet, which is that the government can and has routinely blocked access to certain websites or to certain content. It could be news that is important, or it could be certain access to information that is made available by other people. And the reason that people who think that such a power should not really exist in the current manner is because a lot of these orders of the government asking for content to be taken down are not made public. They're not available. There is no way of challenging them. And they're generally not reasoned orders. Even if they are made available, they are generally not reasoned orders. And this has been something that advocates have been asking for a very long time, for there to be an open manner in which the government can ask for takedown of content, which can then be challenged if there is a need. Because unless and until, again, it's the right of free speech vis-a-vis whatever interest that the state considers to be important. It could be national security, it could be public order, it could be the privacy of another individual. They're all relevant, and such a power may necessarily have to exist, but it cannot be as unsupervised as it is currently. While takedown of content is one area of concern under the Information Technology Act, the other important concern under for the internet, and not so much because of the IT Act, but the internet itself, is the possibility of shutdown of the internet. Now, the Information Technology Act does not provide for the shutdown of the internet in and of itself. It can only allow for content to be taken down. So what governments have routinely done is to again go back to Section 144 of the CRPC to pass orders to take to stop access to computers and internet and devices that can allow you to connect to the internet. And it wasn't until very recently that certain rules have been framed under another act, which is the Telegraph Act, in order to allow for suspension of internet services. Now, this was again very recently discussed by the Supreme Court in the Anuradha Bhasin case, when Jammu and Kashmir had to go through a lockdown of internet services. And although the Supreme Court reiterated much of the jurisprudence of Section 144 as is already there, and the right to free speech, one important thing that the Supreme Court did and recognized there was the fact that these orders to shut down internet access must be made available to the public, must be made after providing reasons, and must also be regularly reconsidered. The point is, just like the Bombay Police Act of Section 144 of the CRPC, these regular shelf life periods that such orders have allows for the authorities to reconsider if the ground reality has changed, and therefore if these prohibitions should continue. But until the Anuradha Bhasin case, in fact, the internet lockdown or shutdown could have continued endlessly because there has been no time frame that is set. Could have happened with the orders not being made open because RTI applications turned to be useless in that situation. So clearly what is happening with internet regulation is that it's slowly mimicking how regulation is happening on the streets or in other physical spaces as a means of protest. And that's possibly a good trend that's come out of this case. But other than that, the Information Technology Act really is an umbrella. And under this, several different rules have been framed for doing different things. And these rules could be something to the effect of, say, how blocking can happen, and there are rules for that. There are also rules for how particular corporate entities are supposed to continue their function if they have digital information in their custody. Because again, although they are private entities, they do hold a lot of information, and the state feels that it's important that this information and the privacy of the information is protected. So there are rules and regulations for that. Similarly, there are rules and regulations for how it is that institutions such as the RBI or SEBI, these government institutions which hold very important public information, are supposed to ensure the safety of that information that they hold. So basically, I think because of the fact that there will necessarily be very different interests for each stakeholder, there will continue to be these host of rules. And that is something that constantly requires monitoring, because what you cannot slip in through the act, you end up slipping in through the rules. Rules which do not allow for open access to these orders that may restrict rights, or rules that do not allow for constant monitoring. So as long as there is this continuous process of engagement of studying these rules and applying the principles of free speech or the other rights that exist outside of the internet to the internet, and perhaps other different safeguards that are specific to the internet, is really the challenge.
Any good reference on the IT Act? Nice.
So one person who writes a lot and has been following internet regulation is this person called Apar Gupta. Apar Gupta, APAR Gupta. So there's Apar Gupta's book, and he also blogs very regularly. Then there is this organization called CIS. They're based out of Bangalore and Delhi. The Center for Internet Society. They have also got a lot of very good content, information, background papers, and they do policy work, so they're also very keyed into all of this. And there is this organization called the Center for Communication Governance, CCG, that's based out of NLU Delhi. They also have good resources online.
So all what you discussed are in both chapter 9 and 11, right? What you just put to? Is Meena here?
I got 9 Information Technology, yes. Matlab, I haven't actually covered all of these also because chapter 9 is a very extensive chapter which provides for things like cyber terrorism also and the National Nodal Agency, protected systems, a lot of other in details of things that are provided for.
Can you tell whether all these sections under IT Act are defined as bailable, non-bailable, cognizable, non-cognizable?
Yeah. So Section 77 B provides that unless the punishment is for 3 years or less, it's non-bailable. If it's for 3 years and more, then it's a bailable offense. And also it provides for cognizable, non-cognizable. Just 1 second. Um, so if it's less than 3 years, then it's non-cognizable bailable. If the punishment is for 3 years, it's cognizable bailable. And if the punishment is for more than 3 years, it's cognizable non-bailable. And again, the range of punishment is quite vast in this because they also cover things like cyber terrorism. So it goes from about 1 year to even life. So there is a range of punishments, and the cognizable, non-cognizable portion is provided for. Also, 77A provides for compounding of offences for minor offences.
Recently, there was this Director General of Police had some meeting where they decided to surveillance of WhatsApp groups, etc. So, does it also come under this like Bombay Police Act and IT Act combined, or like is it comes under IT Act? How does that work?
Okay, so surveillance, monitoring, and decryption, all of that comes under the Information Technology Act. That is again something that the government is empowered to do. So under Section 69, they have the power to intercept, monitor, decrypt. Under Section 69B, they can monitor, collect traffic data, etc. So that would come under the Information Technology Act. And in fact, there are rules for how this is supposed to happen. But again, these rules do not particularly provide for these orders to be made available publicly. So there's a lot of misinformation and opaqueness in the manner in which these encryptions and interceptions happen. Although Section 66 has been struck down, it doesn't mean that that comments on Facebook or WhatsApp or the internet have not attracted criminal charges. Because we continue to see that. Even recently, somebody said something against the chief minister, and he's had and they continue to use IT offenses if they cannot use the IT Act, because the IT Act right now, as far as speech is concerned, is only restricted to obscenity. But they do continue to use IT offenses even for content online.
In fact, just to add to that, I think the intermediary rules under the IT Act
Yeah.
grants exemptions to a lot of social media as we know now. And
Right.
there's a recent draft rules amendment to the draft rules that's trying to bring WhatsApp as an exemption to this intermediary rule, but that's yet to go through in Parliament. So we'll have to see what happens there.
Yeah. So I'm glad you raised that point because intermediary liability is again something that's constantly discussed and debated. Because all of these takedown notices that the government comes up with are in fact sent to these intermediaries. And they're the ones who are supposed to take down the matter. And by intermediary, I mean the people who provide the infrastructure for the internet to run. Sort of, and I'm really oversimplifying this, but the government sends this takedown notice to an intermediary, and an intermediary is supposed to then follow suit. There have been exceptions that have to be introduced because otherwise intermediaries have been liable for not following government orders or for taking decisions themselves sometimes in the fear that the government may ask for certain content to be taken down. So by virtue of being a growing interest area, the intermediaries are also sort of looking for more clarity on how and what they are required.
Right. So as of today, I don't think group admins can be held liable for whatever their acts are. But especially with this COVID scenario, we're seeing a lot of circulars and advisories that are coming out saying group admins should be careful as to what is being circulated and stuff. But I don't know what the standing in law is with regard to if they can be held accountable or not.
See, as things stand, no, they can't because there's a particular exception for intermediaries insofar as the content is concerned. But if they don't follow these orders, then the Act does provide for liability to exist there because you're basically then not following the government's order for takedown. You are not, you don't have the responsibility to either contribute to this is illegal or not, but you do have a responsibility once it is an order asking, directing you to take.
We at this point we are not clear whether all these circulars will stand in court or not regarding the WhatsApp administration and where they are saying they will be prosecuted or not. What the problem is that this point is time is what police can arrest them, and then it is a matter for court to decide whether these orders were sufficient, whether they were within the framework of law or not. So the issue is that at this point, whether initially people can get arrested, that's always the case, and then it is up to the court to decide whether there was a case made out or not. Also, like I have seen some of the cases where now regarding the COVID situation, the Disaster Management Act and the this act, the Epidemic Act, under both the circumstances, the offences are bailable and they are non-cognizable. Now, the police, though they are saying they will apply 188, 188 is also a bailable section. So, if they want to arrest only under these sections, they cannot arrest. They will have to release the person immediately. But if they want to finally arrest the person, they will have to add additional sections against the person and then arrest it. It will not only stick to 188 of IPC and Disaster Management Act. So when we think of what are the sections that the police might apply against the people, we go back to section 353, that is obstructing a police officer in a duty. That is the easiest section, and the very harsh punishments, and now it is triable by sessions court. So we'll have to take into all these considerations when cases are being filed.
But for these takedown notices or for intermediaries to be directed, they have to follow the process of the IT Act. So whether it's an advisory or not, they would still have to go through the IT Act, is what I feel. Challenge it. And what is the point of having these rules and regulations under a particular?
Yeah.